Welcome to today's episode of the Ecommerce Revolution Podcast, where we dive into the dynamic world of e-commerce and uncover the tools and tactics that empower today's emerging entrepreneurs. Our podcast is part of our community with the same name. The community is geared to providing emerging e-commerce entrepreneurs with courses, content, and coaching to help you all launch and grow successful businesses. Check us out at ecomrevolution.co. Let's get things started. Welcome to another episode of the Ecommerce Revolution Podcast. Today we're diving into the legal world to understand what legal matters emerging e-commerce entrepreneurs need to know to get their business started and what they need to know as they scale. Our special guest today is Damian Guzman, founder and legal counsel of Enigma Tech Legal, which offers fractional counsel, which, by the way, for those who don't know what that is, that's part-time and on-demand counsel to startups and small businesses. With 14 years of practice with big law firms as in-house counsel to tech companies such as Visa, everybody knows who Visa is, and most recently as the head of legal for mid-sized fintech startup, Damian's expertise ranges from pre-formation, which we'll be tapping into today, formation and post-formation legal advice, including governance, financing, hiring, and contracting. All very important elements that you need to know as an e-commerce entrepreneur. He's also a certified privacy and payments professional. His superpower, because we always want to know what our guest superpowers are, is that unlike most fractional and outside counsel, he has spent several years practicing in-house. And he also has founded a tech company. So, without any further ado, and maybe I should just say without any further ado, I should also say that he's a member of both California and New York bars. So that means he can practice in both states. So without any further ado, I welcome Damian to the E-Commerce Revolution Podcast. Welcome, Damian. Great to have you on the show today.
Thank you very much, Ramin. Great. Thank you for the introduction. Really appreciate it. I'm happy to get started talking about, how businesses get off the ground and get up and running, and hopefully, do that in a liability conscious way.
Yes.
Do want to state that even though I'm only, licensed in California and in New York, the type of counsel that I provide, which is mostly advisory and not court related, I can pretty much advise clients all over the state of, all over the United States. So I'm just FYI there.
Yeah, no, that's great. And is there anything legally that we need to say before we get started here? Because this is a little bit of a different podcast than we usually do. We're speaking to an attorney, and there are some probably rules out there that we should put out there. So go ahead and tell us what you need to say.
Thank you, Ramin. Yes, and just, my standard, I think most lawyers give their standard disclaimer is that, I am not your lawyer. There might be one of my clients online at the moment, but this is not legal advice. The information that I give on this call or on this podcast is for informational purposes only.
Great. Well, I appreciate you saying that. I know it's very important. This is an area, as I've learned along the way, legal tends to be one of those things that businesses, especially small businesses, startup businesses, maybe the ones, the emerging, maybe they don't have a lot of capital, they tend to ignore, and they don't really know how to navigate this world. And I love the fact that you are focused on that small business world, and you really like to provide, and you and I have had a number of conversations outside of this podcast, and you really have a passion for helping small businesses. Tell me before we get started, where does that passion come from?
Sure.
Why focus on the small business when there are big, huge law firms out there, and that they pay attention to big businesses? What's your angle on that?
Yeah, so I kind of am taking a different approach, and some people might call it leaving money on the table. I don't look at it that way. I look at it as I am a successful attorney. I've practiced for many years. I've done the $1 billion deals. I've done the big law firms. I had a Park Avenue office, 46th floor in New York City. Wow. Did all the things. Practicing in-house for Visa was a great experience. I learned a ton about payments. And even being head of legal for a mid-stage startup, I feel like I sort of have done what most lawyers kind of see or set out to do. Last year, I sort of had a personal, event. My mother passed away unexpectedly, and I took a sabbatical, so took a break from life and my career. And coming out of that, going back into the sort of the world that was working in before just didn't make sense to me. I wanted to do something that was a little bit more kind of, better. Made me feel better about what I was doing with the rest of my life and the rest of my career. And what came out of that was, Enigma Tech Legal, which I set out to be a fractional counsel practice for those types of startups that I would typically work in-house for. But by keeping my rates low, I was able to attract a lot of small businesses. And, my employee, Cecilia, will tell you that, serving small businesses, giving them access to legal services and advice that typically only large corporations can afford, changes things, I think, for the better. The types of clients that I'm able to support, such as, mom and pop shops. I have a mother of three who's a single mother of three who was looking to buy a business, and, being able to support those types of folks feels really good to me. So I kind of found the passion kind of by accident, by just trying to keep my rates fair to clients, and I love it.
Well, I love that, some say we're leaving a little money on the table as well at the Ecommerce Revolution, because we focus on that emerging e-commerce entrepreneur. And a lot of businesses out there are paying attention to the 7-8 figure businesses. And so I love your approach. And I'm sorry that, what had happened but big life events like that, open our eyes, right, to a different way of doing something. And I appreciate that you're doing this. I truly do, because, I am also a small business. I talk to entrepreneurs all day long, and this is definitely an area of confusion, honestly, like what to do and what to get into. So why don't we just dive in, if you're good with this, and let's jump into some questions that I know that our audience, has, questions that I have, questions that I've heard along the way from other entrepreneurs, about what to do. And I think let's start off with formation. This is an area that you're an expertise in. The number one question I always get is, when should I be an LLC? When should I be an S Corp? Why should I do that? What does the sole proprietor mean and all that? And I think I'd like to understand, more from a standpoint of, what are the requirements involved in forming? Why should I, maybe you can speak to the why part of it, if there is a certain timetable of when a business should do this. But, how do they do it? How do they go about doing it outside of, maybe, they contact you directly to do this, but also what else should they be aware of?
Sure. So I want to just kind of set the baseline. So the baseline is, when you do business without any sort of formation or kind of registrations or anything like that, you're doing business as a sole proprietor. So if I go out front and set up a lemonade stand and sit out there and sell lemonade for $1, I am operating as a sole proprietor. That means that my personal assets are subject to claim by someone who gets harmed, and I'm saying that broadly, gets harmed by my business. So if I use water that is somehow infected with some bacteria, and somebody drinks that lemonade and gets sick, my house, my car, my personal assets are potentially at risk, and I can be sued for that harm that resulted from my business. I therefore always, and there hasn't been a scenario yet where I've met a sole proprietor, somebody who's just doing business. They could be, a house cleaning service. They could be a mobile coffee service, where I don't say, get an LLC set up. Because what an LLC does, as well as a corporation, it typically shields your personal assets from claims by others that are harmed by your business. So if I had, for example, before I went out front and started selling lemonade, I set up Damian's Lemonade Stand LLC. I go outside, I'm serving this, somebody gets sick because there was contaminated water inadvertently served to that customer, and they get ill. They sue the LLC. And there are some exceptions to where it's called piercing the veil. You might have heard that word before, but what lawyers, when they say that, it means that, even if you have an LLC or a corporation, there are some factors that may be present that where a court will say, we're going to go after your personal assets, even if you have that shielding. But for the most of the clients that I've dealt with, that rarely, if ever, happens. There are ways to make sure that you are operating as a business and as an independent entity. You're not just creating the LLC to shield against a particular act or behavior. So just with that caveat, when you have an LLC and I go outside, or if I have an LLC and I go outside and I serve and somebody gets ill, they sue me, they sue the LLC, and the LLC's assets are subject to the claim. They can't come through and then go after my house, go after my vehicle, my personal cars, my personal bank accounts, my retirement fund. Those are all shielded. So even though, as I believe that in California at least, there's a mandatory franchise state tax of a minimum of $800 per year. That's sort of the cost of doing business as an LLC. Personally, and this is what I advise my clients, is that cost, as well as the filing fees, which are about $150, that cost, let's just say $1,000, is worth the protection that you get against your personal assets if somebody gets harmed or claims that they're harmed because of the business that you do. So with that said, would you like me to kind of go in through the specifics on?
Yeah, I'd love to know, the specifics, and this differs state by state as well. I mean, there's the $800 in California, which I was very well aware of because we used to have a California corporation. And then when we moved to Texas, it's different. The structure is different. The process is very different. And this is, I assume, true for all states, correct?
True that the specifics in terms of formation may differ. But the general gist is the same. So just to kind of back up a little bit. So each state has its own laws that govern its businesses. So it's corporations. So you might hear, people saying, I want to form a Delaware corporation, even though I'm in Texas. And there are reasons why you might want to do that, which I'm happy to go into on this call or a subsequent call podcast. But the general gist is a limited liability company generally shields your personal assets from claims against the LLC. Same is true for a corporation. That's sort of the purpose of a corporation and an LLC. There to create a distinct business entity that can do business and shield your the directors or the officers or the shareholders' personal assets from claims so that they could operate freely as a business. I have practiced and formed so many LLCs and corporations out of Delaware, out of New York, out of California. The process is different, and a lawyer can help you go through the different state laws and make sure that you're complying with each of them. California's I'm very comfortable with. New York's I'm fairly comfortable with, and Delaware I'm fairly comfortable with as well. In terms of kind of being able to kind of dig through what the LLC Act for the corresponding state says about what needs to be, for example, in your operating agreement and what needs to be in your articles of organization. Again, you don't necessarily need a lawyer to form an LLC or a corporation. I highly recommend it. And we can kind of get into why if you would like, Ramin.
Yeah, sure. I mean, which is also the other question that always comes up is, why can't I use LegalZoom? Why can't I use Rocket Lawyer? Why can I not, why do I need to spend the money and the time that goes into hiring a lawyer? I know this may be a hard question to ask an attorney, but I would love to know your opinion. Like if you were on the other side, what would you be telling somebody, yes, in this case you need a lawyer, or in this case you're okay with LegalZoom, or maybe you should just have a lawyer no matter what?
So thank you for that question, and I don't mind answering it honestly at all. So just so that you and your listeners are aware, I have three key values with which I do my operate my practice, and it's fairness, transparency, and efficiency. I am very blunt when it comes to being asked questions, as long as it's not obviously confidential to a client. But to answer your question, so you can technically go on to LegalZoom. We all know this. You can go onto the Secretary of State of California's website. They have a really awesome website called Bizfile, .ca.gov, I believe is the URL. But it's very handy. It's very simple. It's handy because anybody can go in and form their own LLC or their own corporation. You can find forms on LegalZoom. You can find forms on the Secretary of State website too that will give you your operating agreement if you have an LLC and your a set of bylaws that for a corporation. There's essentially the same thing. It's basically the document that governs an LLC or a corporation respectively. And you can form your entity on your own without a lawyer. And I've had clients who've done that who I've subsequently then engaged with, and I always ask them, send me your formation document so I can see what's in there. And we'll find in every case something needs to be fixed. So what I would recommend is if you can find a lawyer who is affordable to you, I would recommend having your lawyer do the formation, or at least consult with you with respect to forming your corporation, so that you understand what are in the bylaws. When your bylaws are your operating agreement, you're basically agreeing that the company is going to stand by them and operate to them. If you don't know what they mean, how are you going to operate to them? I guess the big topic nowadays, and I know we're going to talk about it a little bit later, but is AI, ChatGPT. Anybody can go onto ChatGPT and say, draft an operating agreement for a California LLC. It'll spit out a document. You're like, okay, cool. I got an operating agreement. I sign it, and that becomes the operating agreement of the LLC. If you don't know what's in there and you get sued potentially by another member or another owner of the LLC, that could be problematic, right? Because you're basically saying, I am entering into a contract that I don't understand. When people say, oh, I got my document off ChatGPT, it gives me the chills, because it's sort of like, that, do you know what you agreed to? Do you know what you signed? A lot of people will go on there and get an NDA. And then they come back to me and say, oh, by the way, several years ago, I lost a client because all of the IP that I thought I had rights to, I didn't have rights to because I didn't know what I was signing. Wow. So I know we're going to get into IP specifically on a subsequent question, but my advice, and this is something that I would say, knowing what I know as a lawyer, and truthfully and honestly, there are very few instances where I would advise a client to draft or enter into a contract without an attorney drafting and or reviewing that contract, so that you understand what risks are there. There are provisions that, if they're in a contract, are not enforceable. Meaning there may be a scenario where you've agreed to something, you think it's perfectly fine because the other party has to agree to it, and they have to perform to it, only to find out later that it's void in California because California has a law against that particular provision. So general rule of thumb for me is always have a lawyer. Lawyers are not always affordable, as I am very well aware of. There are organizations that you can connect with that will help you find a lawyer who can be affordable. Some of them offer free services for some amount of hours. I work, for example, with the Sacramento MBDA, the Minority Business Development Agency, and any member of the MBDA, Sacramento MBDA, can get 3 hours of free service by me for free. So, there are organizations that can help. And going without a lawyer because you can't afford it is, in my opinion, kind of double whammy, right? Because not only can't you not afford a lawyer, but you also are potentially taking on liability that you don't understand, which can cause you more harm later on.
Yeah, no, that's great, and I think that's probably one of the best answers I've ever heard about the why between the two and the difference between the two. Because yeah, sure, it's easy. People, yes, I know AI has definitely changed the playing field in terms of us creating content in all different manners. Now, including legal people feeling like, hey, I've got a lawyer at this AI thing, and it just spit out a great document. But the fact that if you don't know what you're signing or you don't know what you created. Not to mention the fact that AI gets things wrong, still plenty of time. So that's a great explanation there. I want to jump to terms of service, TOS, because I think this is another area, that kind of feeds into this. We as e-commerce entrepreneurs, a lot of times we see this link at the bottom of a site that says terms of service, TOS, and we don't even know what it is. And sometimes if we're on a platform like Shopify, we can generate it using their template system. We can generate a TOS because we were told that that's what we need to do. I guess what I want to know is, first of all, what is a term? What are the terms of service? And how should an e-commerce entrepreneur effectively use terms of service for their business?
Sure. So terms of service are a contract. Typically, when you hear the word terms or conditions, that usually means that there's a contract that is being at least set forth for parties to agree to. With respect to a website, you typically have the terms, and if anybody's interested in seeing mine, I have mine, transparency. I have my terms online for everybody to see. It's if you were to engage with me as a client, those are the terms that you would agree to, and you can kind of get a sense of what is in my terms that would apply to a legal practice. And it's enigmatechlegal.com. Tech being TECH, so Enigma, TECH, legal.com.
We'll put that in the show notes too. We'll make sure that's in the show notes.
So, what does that mean? So typically when you say, and this will be in your terms of service typically, or maybe in a checkbox when you sign up for to get access to the website, but it'll say by accessing this website or by reviewing or taking advantage of the services provided by us, you are agreeing to these terms of service. And that binds the party. So it's a contract that you are agreeing to, meaning that there are rights and obligations that the business, your e-commerce business, is agreeing to with respect to each user who is also agreeing to those terms. So typically, the way that I go about getting sort of the terms to apply to a client is I send out a really short one-sentence engagement form that says, I've read the terms of service available at blah, 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 and I agree and understand what they mean, essentially. And then when the parties sign that engagement form, it becomes a contract between me and the client. Those terms kick in and are binding on the parties, meaning that what it says in there, what it says that Enigma Tech Legal has to do with respect to the client, with respect to confidentiality, with respect to data collection, data use, and we'll get into the privacy policy later. But I am agreeing that I'm going to do the things that are stated that are my obligation in the terms of service. What the client is agreeing to is they're saying anything that the terms of service says that the client needs to do or is obligated to do, they're legally bound by those terms and conditions as well, or terms of service. So what does that mean? What does it mean to be legally bound? It means that if I don't do what's in that the terms of service, then the client, who's the counterparty, can effectively seek remedy, meaning that they can go to a court. They can, we're going to get into disputes a little bit later. There are ways you can massage how that process of disputes works. But they can say, hey, Damian, you didn't do X, Y, Z. The contract says that you were supposed to do X, Y, Z, and I was hurt. I was harmed by your failure to do X, Y, Z, and you owe me now for that damage that you had caused. The other side, of course, is the client doesn't do what they're supposed to do under the terms of service, and I can now hold the client legally bound, meaning I could seek legal, kind of a court order or a judgment against that client if it goes to court, which there's a whole process that lawyers, a good lawyer, will try to kind of get you to resolve the dispute before it gets to that stage. But that's sort of the gist of it. That's what the terms of service effectively mean with respect to you and your website's users or your services users. Now, whether you go about how you go about developing those terms of service is it's an art. I've practiced for over 14 years. Contracts are pretty much what I've spent my entire career doing on a daily basis. So, terms of service, again, it's a contract. So I know what can go in a contract, how it should be drafted, how detailed it needs to be, how vague it needs to be, or could be, to make sure that the parties are both comfortable with what their respective obligations are, so that they can perform to them. There's a whole other section of the law, and it's not really always need to be a lawyer doing it, but it's compliance. And compliance we could have a whole separate call on, but it's basically how do you as a business comply with the various legal obligations that are imposed on it by virtue of the contracts that you enter into, the laws that apply to your business, the regulations that apply to your business, and so on. And when you deal with contracts, the reason, again, why I always recommend that you use a lawyer before you enter into a contract is so that the lawyer can ensure that you understand that you could comply with the terms of that contract, so that you don't create a scenario where there's a dispute in the first place. Disputes are expensive. You could easily lose a client forever. And if you had known what you were agreeing to and knew how to comply with the terms, that makes it a lot easier on everybody. That's the best defense, by the way. If somebody says you breached the contract, it's like, nope, I complied with it, and here's why. And a lawyer can also help you, see if that's a valid argument. I think that, in terms of, sorry, you had asked if I believe you had asked if getting terms of service and when you should kind of get them, and online, leveraging, for example, a competitor or another business who is kind of in your space. Lawyers do that all the time. I probably shouldn't say that out loud, but we do leverage other people's terms of service, and it makes sense too. I think, just from an efficiency standpoint, it isn't worth any client's money in most scenarios for a lawyer to draft terms of service from scratch. Doesn't make any sense. It takes way too much time. Lawyers typically bill by the hour. It is not a good idea. If you have a lawyer who is drafting things from scratch, maybe you find another lawyer. What I typically do, and I've had clients who've actually recommended that we do this, is they'll find something that's relatively close to what their business is, and they will say, let's start from there. That'll get us 80% of the way there, and then send it to me, and I'll say, okay. One thing to keep in mind is when you do that, you're taking a document, a terms of service that a lawyer likely created with respect to that e-commerce company. To think that you could then take it wholesale and apply it to your e-commerce company is you're not really leveraging that lawyer's expertise. And a lot of people think that that's, if they do that, free legal services, right? I just got a free terms of service. Like, yeah, but that was designed for this client. There may be important distinctions that your lawyer would have a fiduciary duty to determine applies to your business. And then make those tweaks. Again, one of the biggest things that I tell Cecilia, my employee, this a lot, is what is in a contract, what you put in a contract needs to be true and accurate. So when you have something that's, let's say it's a privacy policy, or it's a confidentiality provision that says, I won't use your confidential information for any purpose outside of performing to these terms of service, that needs to be true, right? Because if it's not true and you don't do that, that's breach of contract. That's when you are potentially liable to the other party for not doing what you were supposed to do. So, so usually what a client, a lawyer client, like somebody in-house, I have clients who I do fractional counsel for, they have in-house counsel. They might say, hey, Damian, here's a terms of service from another company that looks pretty good. I haven't reviewed it very thoroughly, but can we start with that? I'll say, sure. I'll take that and then I'll read through everything, make sure that whatever is in there is true and accurate with respect to my client, and then give that then to my client for them to use for their specific SaaS company or e-commerce company. A lot of information there. And certainly willing to kind of go into any more detail if you would like, but is that responsive?
Yeah. Okay. That is absolutely responsive. I feel like I understand it better than I ever have, because it is honestly, even in our business, it's just a link, in many ways down at the bottom of the site, or it's something, on the checkout page where somebody has to agree to it. And I will say that most people probably don't read them, right? They do not read the terms of service. I mean, we all joke about the tech companies, and when Apple updates their terms of service or terms and conditions. And by the way, is there a difference between the two, terms of service and terms and conditions? Same thing?
Same thing.
Okay. All right. So we kind of just gloss over them, right? Meanwhile, they are truly a contract, and I have heard many situations where they have come into play, especially with big companies and their consumers and things like that. So I appreciate you explaining that, in detail. One other area, which again is a link at the bottom of the site in many situations, is the privacy policy, right? This is another area that, what is, so again, I'll ask the same question. What is, I know that, I think we all understand the word privacy. We understand the word policy, but put together, what is the privacy policy and how does it come into play, and how concerned should we be about it?
So again, like terms of service or terms and conditions or whatever, those a privacy policy is a document that explains what you're doing with the confidential information with respect to a user of your website. So let's just give you an example in my scenario. So I have a privacy policy. Again, it's on my website. Feel free to take a look at it. Don't copy it wholesale and put it on your website, because it's a different beast altogether. But I'll tell you, I went to other law firms, e-commerce sites, and websites, and I looked at a variety of them, and I sort of kind of massaged them together to create mine. I didn't just sit there and draft word for word from scratch and from memory. I don't know any lawyer who can really do that in any case, not without some time. But the privacy policy sets forth a whole lot of things, and from a legal requirement perspective, has to have a variety of things. And the privacy policy generally, I like to say to clients that it provides the what, when, where, and why with respect to confidential information of your user. What does that mean? So confidential information is information that's confidential, i.e. information that's not publicly out there already. If you post, for example, your birth date on, I guess formerly MySpace, which was, I think, public without you having to log in, and that's displayed, that no longer becomes confidential information. So you can't sort of argue that if somebody discloses your date of birth, they violated your confidentiality. So when you're dealing with a privacy policy, the who, what, where, when, where, why, or the what, when, where, why, is sort of like, okay, the who, that's kind of obvious, right? You've got the two parties, you, the e-commerce company, and the other person, which is the user or visitor of your website. The what The what is what are you doing? You are collecting certain information from them, or you may collect certain information from them that may be confidential or personal. It's the way that the CCPA, the California Consumer Rights Protection Act, and the CPRA. We'll get into that a little bit, I think, in this conversation for sure. But the gist is it's information that is personal to an individual. Date of birth, social security number, my ethnicity, my home address, my phone number, right? Information that I, as a lawyer, typically get from my clients, because I want to know who my clients are. I want to know that they are, who they say they are. I might have their driver's license, number and expiration date. I will have their date of birth. I will have their name, their phone number, email address, so on. Things that can identify that individual. So my privacy policy, when I collect that information, I am disclosing to my clients or prospective clients, I'm getting this data from you. And it might include payment information, your credit card number, right? Things that can kind of be linked back to you. And so the privacy policy will set forth the who, right? The what am I collecting? The why is why am I collecting this stuff, right? Why do I need your date of birth? Why do I need your phone number? And it's easy for some things. I need your phone number so I can communicate with you, right? You're my client. I need your email address so I can send you documents from time to time. I need your date of birth for this reason. I need your driver's license for identification purposes. I need your social security number for identification purposes, or for tax reporting or whatnot. So that's the why. Why are you doing this? The when now, typically, or I may, which means I might be asking you for this at some future date. Usually when I initially take on a client, I send them an intake form, have them complete all the information, have them send a copy of their driver's license, and then that kind of goes into a client management platform. And then that's kind of when I have the confidence that this person is who they say they are, and we start to engage. So that's kind of the gist, is you're kind of explaining the who, what, when, where, and why of data collection or information gathering. Now I have to say, so I am a certified information privacy professional and information privacy manager from the International Association of Privacy Professionals, all sorts of acronyms. We live in a world of acronyms. So I do regularly advise clients with respect to the CCPA and the CPRA and what they mean. And I have to tell you, even as a lawyer, this is the book that I use. It's a desktop manual, and it's in layman's terms. And I actually recommend, it's called California Consumer Privacy Act and the California Privacy Rights Act. By David Zetoony, Zetoony. I got it on Amazon. It's about $80 or so. But it's a handy desk reference for anybody, even non-lawyers, to have handy so that they could kind of review them. And it's like, what do I need a privacy policy? Am I covered by the CCPA and the CPRA? And there are threshold questions that will get you there that are in the book and that are in the law. But it's complicated.
Yeah, it seems complicated. And I guess let me ask you. I mean, that book particularly references California. Now, does it differ from state to state, privacy policy rules and laws? I mean, if I'm in Florida, am I worrying about something different than California?
So the way
businesses
that I recommend in all. Most, I'll say not all. The lawyers rarely say all. Most of the larger, sophisticated e-commerce companies, they, have the ability, right, to hire teams of lawyers to do, just exactly that. The general rule of thumb is to have a privacy policy that is the most strict of all of the states in which you do business. So if I just go, for me, and I mentioned this earlier on the podcast, I can support clients from pretty much any state. So if I have a client who's reaching out to me from Texas and says, "Hey, I want you to advise on my privacy policy." First question is, what do you do, right? Who are you collecting information from? If you're collecting information from California residents, right? Like if you're selling to California residents, or if you're collecting, if I'm taking on a client, if I were in Texas, vice versa, you kind of want to operate at the most strict level of what laws might apply. And the CCPA and the CPRA out of California, with respect to the United States, are the strictest at the moment. And so usually if you have a CCPA and CPRA compliant privacy policy for your entire website, and you're only operating out of the United States, that's going to get you 99.9% of the way there, because you're operating to the most strict version of the state laws that apply with respect to privacy policies in the United States. This is true for the GDPR too, out of Europe. So if you're a global company, if you're an e-commerce company that sells things in Europe and the United States, you might do a little bit of a balance. But the GDPR is right now with the CPRA, the CPRA and CCPA are getting pretty close to the strictness of the GDPR, but the GDPR is still, I would say, more strict with respect to data protection, such that an international e-commerce company would probably want to perform or create its policies with respect to the GDPR, and that will cover them in California as well, generally.
Okay.
But it's complicated. Like I said, this is something that it's tough to go through, and it requires some time to digest and to understand and to sift through, for which, again, lawyers may be a better use of your money and your resources than to try to kind of try to absorb it all yourself. I like to say, sometimes, and I know clients do this a lot, sometimes it's good to hire a lawyer so you have somebody to blame if something goes wrong. It's
coming from a lawyer, by the way.
Yeah.
Yes. Wow.
Like
okay.
The whipping child of medieval times, right? It's like sometimes you just need somebody to blame, and it just imagine, so you get an NDA off of ChatGPT, and you execute it, and somebody sues you and it requires, basically you have to pay out X amount of dollars. You have to shut your business because you violated a contract. It's one thing to say, well, I found this on ChatGPT and I signed it without knowing what I was doing, versus Damian drafted it for me and I signed it. And he messed up, right? That's a different sort of, and there are reasons why you might also want a lawyer just for, even for optics. One thing I tell clients, and clients notice, I think, right away, is when you have a lawyer, once they bring the lawyer in and say, a small business says, "Hey, talk to Damian, he's my attorney," the conversation changes, right? It's like now if they were trying to take advantage of that small business, they stop. They've said, "Okay, hold on. What am I saying that can get me in trouble now? I can't bully this person anymore." And so there are a lot of sort of, benefits to having an attorney that aren't just the services that you're providing. It is kind of having somebody to protect you, which is what attorneys do and should be doing, right? They protect your interests. They make sure that you are, able to enter into contracts and to understand what they're doing, that you don't subject yourself to liability inadvertently, and all that good stuff. But yes, back to your basic question is privacy laws. Typically, the best path forward is to operate to the strictest jurisdiction in which you're doing business.
Okay, no, that's phenomenal advice. And I remember back to when GDPR first became a thing. There was panic across the e-commerce landscape for all these companies that were operating, and companies that were not operating because they didn't, nobody really understood, like, do we have to be aware of it? People can pull up our website in Europe, but we don't sell there. So there were all these issues, and I think this world is going to continue to get more complex when it comes to privacy policies, because there's a lot of data out there, and and I think, it's a good thing to protect the data and tell people what you're asking for, and just make it clear, as clear as possible. I want to jump to another topic, and this is, another area that gets a lot of, I don't understand what I need to do here, and that's around intellectual property and IP. Okay, and how can entrepreneurs protect their products? Maybe it's something they've created, their designs, maybe they're selling, virtual wallpapers, right? And their content, which so many e-commerce businesses now are also turning into content production companies, because they have to produce all this content for social media, but also for their internal sites. What's happening in the IP world, and if I'm an e-commerce entrepreneur, what should I be worried about? What should I pay attention to? When should I contact a lawyer?
Yeah, so that's a great question. And I do want to sort of caveat my response that I'm not an IP lawyer. There are certain areas of the law, IP being one of them, that are highly complex. And usually, you have dedicated professionals who practice just IP law for their entire careers. Other areas of law are like tax law, super complex. The tax code is just it's hard to digest even as a lawyer. And so with that, you do have to understand that you probably do have a lot of intellectual property in what you're doing for your business. Taking my my lemonade stand example, I go out front and I make a certain, like, I have a logo, right? It's like I don't know, just a person drinking a lemonade, and it's a cartoon character, and that's like my logo and my brand, and I drew it myself, or I had somebody draw it for me. That is intellectual property, right? I created something. It was intellectual art, and I'm using it for my business, so that the LLC, assuming that I formed an LLC for it, now owns that intellectual property. I want to protect that intellectual property. And how do you do that? Typically, unless you enter into a contract that assigns rights to use that intellectual property, you don't get rid of the intellectual property. It's yours. So how do you protect it? You want to make sure that, again, going back to the contracts that you enter into, make sure you understand the IP provisions. So I've throughout my career, I've supported a lot of SaaS companies, software as a service companies, banking as a service company, of course, Visa. And, in pretty much every contract that you have with a partner who is doing something with you, your business, there's going to be some intellectual property language in there. Either it's going to be a very straightforward disclaimer that no IP is being assigned or transferred by virtue of this contract, which, again, is not terribly necessary, but you might want to have it in a contract just to be super safe that you're not inadvertently giving away rights to your IP. But more likely, you're going to have a very well negotiated provision of IP that carefully, ideally among lawyers, carefully reflect the desire of each party and the willingness of each party to provide certain rights, usage rights to another party. One example that let me see if I can do this in a confidential way, but well, I'll just give you an example of a SaaS company, right? SaaS company is entering into a partnership agreement with another SaaS company, and they're going to be one SaaS company, we'll call it company B, is going to be providing services to company A with respect to lead generation, right? We're going to go out, we're going to find leads that of potential clients that might be interested in your service, and as part of that service provision from company B to company A, we want to be able to use company A's logo. And so, we want to be able to say, hey, we are an authorized partner or referrer of company A. and we're authorized by this contract to provide referral or maybe some sort of a discount or something to pass those leads on to company A. And company A wants to make sure that it doesn't give away its IP unnecessarily, too much rights or too many rights. So what you might have is an intellectual property provision that says, we're going to give you a limited, worldwide license to use. What does a license mean? A license is we're giving you the right to use, but not the ownership of the IP. So you typically see licensing provisions in most SaaS agreements, a lot of e-commerce, provisions. You might have it in your terms of service, right? If you're doing business with, B2B, you might want to have in there that, hey, just because you're doing business with us doesn't give you the right to use our IP. If you want access to our IP or you want to be able to post our logo on your website, you have to get special permission, which we usually call prior written consent. But long-winded way of saying that to protect your IP, you should typically have it in writing. And again, going back to my, whatever is in a contract needs to be true and accurate. You want to understand what the intellectual property provision says, what rights you're giving, whether it's a license or ownership right, what rights they're giving or that they have. So that when it comes, you sign and it becomes a binding contract, that you know how to comply with that contract, so that what you're doing, the use of their IP or their logo or something, complies with the contract. What you don't want to do is, have a scenario where you have no rights to use another party's IP, and you use that logo, and then you get potentially a lawsuit against them if there's a claim that the use of their logo caused them harm. Again, it's all about liability, protecting that liability, making sure that you are operating to your requirements, either by contract or by law. And that's true with intellectual property as it is with any other legal provision that you might want to see might see in a contract.
That's great. That's great. I mean, very, very helpful information on that, because I know that's definitely, as we mentioned earlier, it's a big area, right? It's a big area. We have a lot. Sometimes we actually don't know what we have to protect. We don't even know what can be protected, and I think that's part of the question. Part of the discovery process is to figure out what can be protected and what should be protected. Well, let me ask you a question now about. This is something that I've always been curious about. So let's say I've done all the things. I've got my, rock solid terms of service. I've got my great privacy policy. I've gone the route of trademarking, and I've hired a lawyer to do all these different things. And I've, touched on other areas like accessibility and all these other things that are important. But then I get a legal notice, or I get a summons of some kind. What am I supposed to do? Do I need to get a lawyer right away, or is this something that, if I don't have the funds to hire, that I want to do a little discovery myself? Like what obviously I read it, try to understand it. But what are the steps? And I hope this never happens to anybody that, any of our community members, but it's a reality. It could. What do you do? What are the steps?
So typically, what you're referring to is what we would refer to as a demand letter, and that's a demand letter is a letter by either another party or their lawyer. That you get it in the mail. It says you have breached your XYZ contract with us, and it caused us to incur damages or liability, and we're hereby demanding that you pay up. That's the right thing to do, I think, with lawyers as being the first step. It's usually what I advise clients to do if they have a dispute with another party or one of their customers. I'll say, let's send them a demand letter. Sometimes I send a warning first, followed up by a demand letter. And what do you do when you receive that? So either if you have a lawyer, you get it into your lawyer's hands ASAP. If it's my recommendation to clients is that if there is a reference to Counsel or a lawsuit or a threat, get it into my hands ASAP so that I can protect my client. If I don't know about it, I can't protect my client. So that's sort of, the first step. If it's sent by a lawyer or counsel, or if it's sent by an individual, but they're threatening legal action, get it into a lawyer's hand. The lawyer may say, and I don't, even if a client receives a letter from a customer that says, we're threatening all this stuff, it doesn't necessarily mean that I'm going to respond on behalf of the client. I might say, look, let's look at the contract, right? Depending on if it's a breach of contract claim, which in my practice it most often is. You go through and you say, let's look at the contract. If you look at my terms and conditions online or my terms of service online, you're going to have a very well thought out dispute process section that says the parties are agreeing to, before they go to court and file a lawsuit, we're going to take certain steps to try to resolve the dispute between the two parties. So between my client and between myself. The first step is let's just talk. Sometimes, you might think, oh my God, they breached the contract. I'm upset. I incurred $10,000 as a result, and I had to pay that. And you get frustrated and you send a demand letter, very formal, threatening that I'm going to take you to court. And you're just like, hold on, let's sit down, let's get on a call, let's chat this out. Maybe, there's a misunderstanding. Maybe I do owe $10,000 and I'm sorry, right? And I'll pay that to you. But a lot of times the very first step, and what I have in my terms and conditions, is let's chat. The next step from that is to mediate. What does mediate mean? It means to, usually with a third party, you sit down with a mediator, somebody who is typically trained to help parties resolve disputes. But it really is, I used to mediate in law school, and it really is kind of sitting there, let the parties explain their positions. A lot of times people just want to be heard, right? I feel like you aren't treating me fairly under the contract, and I want to speak my mind, and I want you to hear it. And a mediator will help, a good mediator will help kind of keep the tone, civil, really kind of flesh out what is the ultimate underlying problem, and whether the parties can agree to that. Next step beyond that, let's say that fails. So we had a discussion, ended up yelling at each other. We got a mediator, didn't figure out how to get it to a resolution. You can go to arbitration, which is, I have in my contract, you go to arbitration, which is a private decision maker that the parties agree to contractually to allow that third party to make a decision based on what he or she knows of the dispute. So it's kind of like, a court, a judge, but it's a private, it's not within the court system. It's before you get to court. And then you could take a couple of things. You could say the arbitrator's decision is final and binding, legally binding on the parties, such that they can't just take it to court without getting it possibly thrown out. Or you can say that they, if it fails in arbitration, or the parties, feel like they were unfairly treated or something, that then you can subsequently go to court. But usually arbitration is in lieu of a right to file a lawsuit in court. But disputes, it's a process. There's no real sort of, ideal way to handle it. I personally like the structure that I advise clients on all the time, is to start with a tiered level dispute resolution process, beginning with what we call a meet and confer. Let's talk. And if that fails, we go to mediation. If that fails, let's go to arbitration. That's usually or court. That's usually what I recommend, because I'm a huge fan of, not going to court. I usually tell my clients, my job is to keep you out of court.
Right.
That's I don't like being in court. It's a cold place that I just don't think is, I don't know, it gives me the willies. But that's sort of my job, is to keep you out of court, making sure that you are entering into good contracts that you can comply with, that you understand, and that you can
Mm-hmm.
operate to, that you're complying with all the laws, privacy laws, this book here,
Mm-hmm.
and make sure that you're not doing anything that's going to attract regulators, such that you might have to pony up some money or a fine, or worst case, have your business shut down. Like, that's my job.
Mm-hmm.
That's a good in-house lawyer will keep you out of court. But like you said, sometimes you just get something in the mail that says
Yeah.
you breached a contract because the client is, upset, and that
Mm-hmm.
may be true. You may have done
Yeah.
something inadvertently.
Or
If
even a
you're
cease and desist, right? Even a cease
yes,
and desist. You stop
yes.
using, you didn't do maybe the work necessary on the trademark side of things, and you've got a logo floating out there that is infringing, or a name that's infringing upon somebody. And I always feel that, what do you do? And I think that was a great explanation in what you do in those steps, and I appreciate that. And this has been like a master class in legal. This is, I mean, fantastic, and I feel like we'd love to have you come back on again and maybe dive
Be
into
happy
some
to.
of these other areas that are, that require a lot more explanation, and things are rapidly changing out there. And one area that's rapidly changing is obviously the use of AI, and, how that's coming into the mix. So we can save a whole other, podcast just on the legal side of AI, which I don't even know if it's like defined yet. It seems to be kind of floating. But I want to know, curiosity, as we kind of wrap this podcast up. Do you use AI in your workflow? Okay. Tell me something. We'll go like off topic here, off the legal side of things. What's something you've done on AI that you just stopped for a moment and you said, "Wow!" Like, oh my gosh, I can't believe it did that. I mean, maybe it was something for your practice. Maybe it's just something in your personal life. Is there anything that you can point to that you had that wow moment?
Yes, and I'm still learning AI. So I believe, so again, my three values: fairness, transparency,
Mm-hmm.
efficiency. The last one, efficiency, right? I try to do things as obviously carefully, but with
Mm-hmm.
the minimum amount of time spent. I still, at this point, I charge by the hour.
Mm-hmm.
And my employee charges by the hour. So we what we try to do is leverage AI tools in order to reduce the amount of time that we spend on our clients, which ultimately
Mm-hmm.
brings their rates low, and I can take on more clients, and I can help more people, and so on. But there's a fantastic tool that I use that I just learned about probably a month and a half ago, called Spellbook, Spell Book, and then their domain is .legal, so it's spellbook.legal. But Spellbook is a tool, it's a plugin that you put into Word that gives me a cautioned wow.
Okay.
It definitely wows me, and it gives me caution,
Mm-hmm.
and pause in some scenarios. It's not perfect, right? But what it does is so it's a local AI, meaning
Okay.
that none of our clients' information is going out into ether. As you know, if you go to
Important. Yeah.
ChatGPT and put in a client or your own contract, and it has your name
Mm-hmm.
in there, you've just sent that out to who knows who, right? That's going to
Right.
be used in other responses potentially, to other people and show up. And that could be a violation of your privacy policy. It could be a private violation of your contract. You have to, again, I tell my employee, we have a rule. We are not allowed to use ChatGPT for anything client related. So that's a publicly facing AI tool, and we just don't use it. Spellbook is local, meaning that no information goes from my computer anywhere. It's all locally processed. I understand that Apple's new artificial intelligence is also local, meaning that it doesn't go outside, and potentially used in other people's queries. So with respect to drafting, Spellbook definitely gives me the wow, because what I can do is I can take a lease, for example, a Word version of a lease document. I could use Spellbook, and I could just type in there, draft a demand letter to this customer on behalf of my client. for breach of contract. And what it'll do is it'll get me, again, 80 to 90% of theirs. So it'll just like spit out a demand letter that I don't have to draft from scratch, that I can now take and revise it as needed and maybe save 25 to 50% of the time that I would have otherwise had to spend. And it definitely is expediting the use of the use of my time. I guess it's reducing the use of my time on client matters. I also use a client management tool called Clio, CLIO, that just released its own AI tool, and it's also pretty handy. It can doesn't give me the wow yet, but it definitely can go through all of my clients' contracts and give me a summary of the status of that client with respect to how many contracts does it have, when contracts might be expiring, what's coming up this year for this client with respect to his or her client contracts. So again, I believe in what I call the responsible use of AI tools. Certainly have obligations to maintain the confidentiality of my clients and their legal issues, and so nothing I do is allowed to go outside of my local processing here. But think that AI is definitely changing the game. And I'm seeing it firsthand, and I'm using it and being mindful of it. One thing that's kind of funny is, I was talking to somebody about, use of AI, and it's like, I think lawyers are going to have to get very comfortable very quickly how to charge for their services, because AI is going to make it a lot faster, such that the time may not reflect the value of the service that you're providing anymore. And it's something that I'm sort of keeping sort of in the back of my head as I continue to learn what tools become available. But that said, with respect to my clients' use of AI, I always say just be careful. Don't put anything in an AI query that you don't want out publicly, because chances are it'll end up out publicly. And I certainly, one thing I do want to say is, and this is not my own thought or idea, but someone once mentioned to me, you can't outsource good judgment. So, having a lawyer look at the the tool that you generated from ChatGPT can help you understand what the ChatGPT actually produced for you before you go and sign it and have it apply to you. Funny thing about Spellbook, I love it. I think it's a useful tool, but it's not perfect. I'll have it draft something or ask it to draft something for me, and it's like, whoa, like, if I had just taken it and sent it to a client, I would have probably committed malpractice because of the errors that was in there. And it's like, it's not perfect. And having somebody who has practiced and read through tens of thousands, probably at this point in my career, contracts, to be able to digest what the output is, and then again, make sure it's applicable to your client, is responsible. And that's what I mean by the responsible use of AI.
Yeah. Well, I think, we refer to it as keep the human in the loop, and especially when you have an expertise and you're using tools that are geared around that expertise, make sure that you stay involved. I don't think we're anywhere near that place where we're pushing buttons and they're just doing it for us and it's going to happen. Maybe, who knows, down the road, maybe, Damian, you're waking up in the morning and you push a button in Spellbook and, it's all taken care of and it's all perfect. But we're not there at this point, and it's always good to be careful. And I appreciate your commentary about, making sure what being aware what you put into AI, is going to be used for the masses. So, if you can use a localized AI program, that definitely helps. And especially in your field, you have to be very careful in that area. But I got to say, thank you so much. This has been an incredible, and I absolutely would love to have you come on, and we're going to dive into one specific issue and just talk about that, because, again, this is an area that e-commerce entrepreneurs there's confusion, and I think there always will be. Having moments like this, to learn, an informational time that you can pull information and then reach out. And I think we're saying here is that there is no substitute for an attorney who knows their craft really well, that can help you button up your. And I'm I always think there's two areas in business you invest in, legal and finance. These are two areas I think that, I would never go and profess that I know, I'm an expert. I know enough to just understand, but I need to know. So and I think that's a good, good concept for everybody to take. So as we wrap up here, would love for you to just take a moment and just let people know how they can connect with you directly or through your website, and give us, anything you want to tell us where we can put in the show notes as well.
Yeah, that'd be great. Yeah, I'd be happy to chat with anybody about anything that they're currently, going through or have questions about. I don't believe in charging for consultations, so I'm happy to give a 1-hour consultation to anyone who is interested in having a chat for free. So just something that I'm happy to do. I actually get really frustrated when I reach out to lawyers that I might be looking for, and they're like, "You've got to pay, $400," and I'm like, "But I don't even know if I want to use you yet."
Right.
It's frustrating. So I just take a stance against that. You can reach me at my email. It's Damian, Damian at enigmatechlegal.com. That's ENIGMATECHLEGAL.com. You can also reach me on LinkedIn. It's linkedin.com/IN/ Damian Guzman, DAMIAN GUZMAN. Pretty easy
Perfect.
to find, and happy to chat with any of your listeners. Just reach out.
Yeah, absolutely. Well, I appreciate it. And we'll put all that information in the show notes and highlight that. And that is a very unusual, scenario. Not every lawyer out there is offering to have that consultation. But I think your point is perfect. That how would you know you need to hire somebody or why you needed to hire them unless you actually have that conversation? And by the way, it gives you an opportunity also to say, no, you're okay. You don't really, and your time is valuable. Being able to, focus on as many situations as possible. So thank you for making that. And thank you very much for coming on today. I greatly appreciate it. We will make sure this, gets out there into the community and to anybody out there who is a emerging e-commerce entrepreneur who really needs to understand what they need to be concerned about when it comes to the legal side of things. So, Damian, thank you so much. Have a wonderful rest of your week, and we will make sure that you're a frequent guest. Okay.
Thank you very much, Ramin. It was a pleasure.
Absolutely. Thank you.
Take care.
All right, that brings us to the end of another episode of the Ecommerce Revolution Podcast. Don't forget to check out past episodes, which are all available on demand on YouTube and wherever you listen to your podcast. Ready to join the revolution? Become an exclusive part of our growing community of emerging e-commerce entrepreneurs at ecomrevolution.co. Until next time, see ya.